same. Again, it cannot condition representation on the signing of a non-disparagement clause as part of the fee agreement, refers back to the explanation provided in opinion number 3. And then number 5 also remains the same, and this says that you can't enforce any kind of non-disparagement clause in a fee contract by filing a civil action against the client, by firing the client if they don't sign it, or claiming an offset on unearned fees, or any other remedy at law or equity. So you see in the materials, I provided a track changes version of the opinion, and then there below there's a clean version. So make it easier for you to realize or to see what I took out, what I added, and then the clean version of what was added. That's my summary.
Thank you, Nicole. Based on reviewing any of those changes and so forth, is there anything that anybody wants to discuss about those, bring up, debate?
Yes.
Fair enough. What do you got, Warren?
I'm fine with opinion number 1. I have some questions about opinion number 2 with regard to the non-disparagement agreement. First, are we talking here only about non-disparagement agreements within the context of a fee dispute only, or is this prohibition on quote truthful statements? Not prohibition. This part about how you can't prohibit truthful statements with a non-disclosure agreement. Would that apply to any release of any attorney for any claims against that attorney? I understand, obviously, that the non-disparagement agreement can't restrict a lawyer or a party from, in the future, making a grievance against that attorney. That is prohibited, always has been prohibited, and shouldn't be included in a non-disparagement agreement. But I think part of the point of 95% of all non-disparagement agreements are that client is, the opposing party is, or all parties to the agreement are prohibited from talking about it truthfully or otherwise outside of the context of entering the settlement agreement. And if this were true, then lawyers proposing settlement agreements that included non-disparagement agreements or non-disclosure agreements in any settlement would be somehow prohibiting another party from saying truthful statements outside the context of the and therefore all of them should be unethical. So I think it's gone too broadly when it talks about that. I also don't read Rule 8.4 on the part about prejudicial to the administration of justice to be that broad. We're talking about non-judicial statements by former clients in the context of Google reviews, like this whole thing came up before, and other places that they may want to post things. And I just want to make sure that if we are proposing something that broad, we're going into it fully aware that there'll be a lot of discussion. And I believe pushback on this.
Well, Warren, my intent was that it was limited to resolving a fee dispute that has been filed with the fee dispute program at the state bar. But I will leave that up to the committee to discuss. Do we need more narrowing in the language to exclude other things, or just to limit to fee dispute?
But is Warren's point that the rationale I understand that this opinion is limited to, it is just for that limited circumstance, a fee dispute with a fee dispute resolution. But does the rationale and the application of the rules that you cite, does that make it applicable broadly? I think, is that your concern, Warren?
100%, yes. That as it's worded, I'm just afraid it will be used by folks to say it was an unethical non-disclosure agreement, and thus make many, including all of Lawyers Mutual's agreements that we have out there at the present, and I'm sure many others, if that's unethical, to have proposed it in a contract, then it can't be enforceable.
This is Bill Powers. I kind of join with some of Warren's concerns. There are a good number of times where we as counsel will agree to refund a fee, even if we don't think it's appropriate, to avoid fee arbitration, to not make the client go through that and attempt to do the right thing. If you're not allowed to negotiate out people going in and disparaging what you did when we can't really comment, no one's ever going to settle anything or even agree to even try to settle things. We'll say, fine, take it to fee arbitration. We'll argue it out there, which is, I don't think, in anyone's best interest. So I would prefer it not to be triggered by the requirement, if that's what the intent is. I may be misunderstanding, but trigger and requirement that it has to be through fee arbitration. There are just times where there's a parting of ways or something settles quickly that even though let's say there's a true general retainer and you just think it's the right thing to do to refund a portion of that, even though it's not required, you should be able to say, we're not going to discuss it, or add language that if there was a dispute or a question about it, so add some language to the fact that the matter has been settled amicably or something, and then also add language that nothing shall preclude this person from enforcing or otherwise seeking the assistance of for a violation of rules of professional conduct. I think there's some limiting language we could put in there. I'm just concerned of a more of a blanket statement that actually actively encourages lawyers not to try to, settle things up.
Because correct me if I'm wrong, but isn't, like, at least Warren, with respect to like Lawyers Mutual settlements, assisting lawyers settle disputes, isn't a confidentiality provision pretty standard in almost every settlement agreement? And so like a confidentiality where you're not allowed to, to talk about it, I think we're talking about non-disparagement, like, hey, you can't post on, Google reviews or whatever. But the problem is it's sort of a slippery slope, right? And if, do we get into a situation where what we're saying is that you can't include any kind of confidentiality provision really anymore in any kind of settlement agreement as a lawyer without potentially running afoul of the ethical rules? Is that what we mean?
I don't think that's what we mean, but I'm afraid that the way it reads, it could be construed that way. I mean, I don't want to speak for everybody. I don't know why I just said I don't think that's what this is intended to say, but
It is not.
It may be what people want to say, but I don't think that's what it's intended to say. And I just I feel about, if we limited it just to saying it doesn't prevent the client from filing grievances, it's not coercively presented, and it doesn't, limit the client's access to fee dispute resolution program or other disciplinary process, that we're okay, that we're kind of okay with that. And then you were not getting into the realm of telling people that they can, despite the confidentiality clause, they can go around and in public and say what they feel is truthful. And then, because I mean, that's truthful otherwise. Confidentiality statements are not there to prevent people from saying truthful things. They're there to protect, people's reputations. And that's why people engage in negotiations and to do them. And so, as Bill was saying, if what's the advantage of returning anything to somebody if the client reimbursing anything to a client if the client can then turn around and say, well, truthfully, Bill's a shitty attorney. And I don't think that's that is which he's not. He's awesome, by the way. But
Wait, which bill are you talking about?
Powers. I just got all of them. They're all good attorneys. But
just when I got the live stream working, Warren goes and drops an expletive about another attorney
all
on the
right.
call.
That's all right.
No.
But I hope you get my point. It's just the allowing. I don't think, obviously, if it prohibited a client in a judicial setting from making truthful statements under subpoena, I mean, that's ridiculous. That's not what we're trying to say here. And on the other hand, judges and we're getting beyond our jurisdiction to even say what would or would not be allowed. A judge should allow a client to say under subpoena. We're not trying to interfere with that, but where clients might want to go and even after settling a case and relitigate things in the public, non-judicial public forums, that is one of the biggest reasons many lawyers want to settle a case.
Would it be more narrowly tailored if instead of the answer is it depends, the answer was yes, provided? So like, yes, you can, provided that it does not limit the client's rights to file a fee dispute or a grievance. Like put those as provided as opposed to it depends.
I like that better.
Okay.
Yeah,
Okay.
I like that too. I think.
Okay, so we're taking out, or Warren and Nancy, your recommendation is that we take out everything from like the paragraph that starts with a broadly worded non-disparagement, and just go down to those three things. Yes, provided that you don't
Yeah, like
prevent the
my
filing
thought
of a
would be,
grievance.
yeah, yes, provided the non-disparagement provision does not, and then those things that we're concerned that it would violate, it does not prevent a client from filing a grievance with the state bar, from seeking assistance through the fee dispute resolution process.
And is not coercive
Yeah, yeah.
as a condition to resolve. Okay.
And maybe, and is not a condition for the return of what is a clearly unearned fee or something like that, because that's the other piece of it, right?
Right. Which you addressed right at the beginning, right?
Yes.
Yeah. Be careful with that, or speaking truthfully in those three conditions too. That's
Well, and that's where I was going to suggest speaking truthfully. I think the intent was speaking truthfully as it relates to the disciplinary process, or
yes, clearly. I'd even say they can lie to the disciplinary process. I mean, hell, clients do that all the time when they not all the time, but sometimes do that when they file a grievance. They lie. But we're not telling them they one way or the other. We're trying to limit what they say in the context of a grievance, truthfully or otherwise. I don't think that a lawyer could even bring a defamation claim against a client for filing a grievance.
Well, maybe it'd be better to say it doesn't prevent the client from filing a grievance complaint with the state bar or other professional regulatory authority, or participating in the disciplinary process. I mean, I think
I like that. 100%. That's good.
You don't want to lay out all their options, right? Like fee dispute or grievance. Yeah, just disciplinary. I like that better.
Yeah, I like that.
Can I ask one question about, I know we're still on this, but this is related. The last part of it, am I reading that correctly? That if our answer is yes, you can have this in, provided that it doesn't violate these other things. But then is the last one saying, if you have it in there, you can't enforce it? I mean, is that what? Do I
when you're
understand?
saying the last one, what?
The last, hang on, I'm having to toggle back and forth on my
sorry.
laptop. So let me,
I was on mute. I think you mean inquiry number 5.
yes, inquiry number 5. So am I reading that correctly? That let's say you have this in a settlement agreement with a client, you have a provision that doesn't violate the what we said, they can file a grievance, they can do whatever. But even if it's one that would pass muster on ours, number 5 would say you can have it, but you can't enforce it.
Nicole, is number 5 specifically referring to the provision that's described in inquiry number 3 as opposed to?
It's supposed
Yeah,
to
it
be the same facts as inquiry number 3.
Okay.
Right.
So it's
We can add
it's
that.
including it in the fee agreement.
You
So I
might,
think Nancy's
I don't
right. I
know, it
think
might
we
be
need to
clearer just
clarify
to
that.
make, yeah, it might be clearer just to say that with respect to the facts of number 3 and then that. I don't
think
know.
that's correct. Yeah, no, I think it'd be helpful.
Anything else there as
Anybody?
to opinion 2? Or does everybody seem good with that proposed wording change?
I'm fine with it, sure.
If I understood from our committee members, there was also in terms of the response for number 2, whether it would change to yes, provided that, or remain as it depends. Do we want to make sure 1 and 2 track similar logic in terms of that initial response? So we don't have one that says it depends and one that says yes, provided that.
That's
So-
a good idea.
For whatever it's worth, can I just suggest that the it depends language, I don't know, I feel like it fits more because at least my understanding, I think the subcommittee still wants to emphasize the point that if a refund is owed, if the lawyer is professionally obligated to refund the fee, the answer is no. And that they cannot have this non-disparagement kind of tack on. It depends because we first have to answer that question. And if the dispute that's ongoing really truly is a legitimate dispute that results in effectively an impasse, and there's no professional obligation to refund, I think that's what then opens the avenue for this conversation and the potential inclusion of this clause in any sort of resolution. Am I understanding, am I tracking the subcommittee's the feelings that way? And I guess maybe that's where I feel like it's kind of like the first question is there actually a professional obligation to refund? If yes, the answer is no. If no, let's move on. And so that to me makes it depends a bit more appropriate. But that's kind of my gut reaction.
I have a question about that I'm struggling with, and maybe I'm missing this, but the question about whether a refund is clearly owed or not, how is that ever ultimately resolved? It almost is like you have to have step one, step two. Well, most fee disputes that I've ever, been involved with, either as a mediator or limited personally, there was typically never a full agreement about whether it was clearly owed or not. It was simply a compromised deal where the lawyer probably felt like the fee was fully earned and the client felt otherwise, but they strike a deal. So I don't know how you ever get a clear yes or no to whether a refund is owed or not. That's what I struggle with.
Yeah.
That's the reason I had an issue last time with collateral benefit, being attached as a condition to settlement of that. And I'm just not comfortable or clear about how that happens.
So may I just point out that the fee dispute facilitator is never going to make a determination about whether a refund is owed or is not owed, because they're really more in the role of a mediator. They're not adjudicating. So the fact that it reaches impasse doesn't really tell us anything about whether the fee was earned or not earned. It seems like to me that what we're doing is putting the onus on the lawyer to make a judgment, a fair judgment, about whether the lawyer owes a refund. And, theoretically, that could end up in front of the grievance committee, which might disagree with the lawyer's assessment. But like so many of the other things under the rules of professional conduct, they're written pretty broadly to put the burden on the lawyer to make the judgment about whether this applies to my situation. And so I think that's consistent with what is often done.
I
I know it
agree.
may sound like obiter dictum. I just kind of wish we could put something in there that says that counsel is encouraged, to, or always called to be proceed with good faith, but, like sometimes even if we're not asked, we just do it just because it's the right thing to do. And it would be nice to be able to say, I'm going to do this. I'm not required to, but I'm going to do this. But I agree that it's hard to tell because sometimes some of the fee would be earned someone, and it's the nitty gritty where things get confusing.
Right. And the client could be saying, if he hadn't have been incompetent and hadn't messed my case up, then he would have earned this fee. But he messed my case up, and that's why I have a malpractice claim that I want to assert. I mean, that I don't think there's any kind of way that this can really be resolved one way or the other,
I
other
agree.
than saying you, the lawyer, have the responsibility for making this judgment.
Right. And that lawyer's going to be answerable if he made the unethical call to try to tack on a legal malpractice release onto a return of a fee that he clearly didn't earn, and they turn around and report him, then that's especially with this, would be an additional grounds for, not only did you owe them back the fee, but you tried to impose this thing on them that you should have known they didn't have to retire. Hopefully most of this is also taken care of. Anytime you offer to do a settlement like this, you're still required to tell the client to get separate counsel to advise them on whether they should enter into this and give them the time to do it. So they might go to somebody else and explain to them what happened, and they'll go, hell no, don't sign that release.
Right. Well, based on my experience with the grievance committee, I don't think that there's cause for concern that people are going to go from the fee dispute program and then be second guessed by the grievance committee. I mean, I don't think it would be a situation where the grievance committee was substituting its judgment for a different judgment that the lawyer reasonably made. It would really be a situation. And
Right.
again, this is all about 1.5, which talks about a clearly excessive fee. Clearly not being, 50, 49, 51, but clearly so.
Right.
In my experience, the grievance committee is not looking to play gotcha with anybody.
I think that's helpful. Also, what you were saying is that the fee dispute commission, they act as a mediator, not as an adjudicator. I've only had one, and a couple of years ago, and it was when I sent the letter out saying I was going to file a lawsuit. They filed a fee dispute, and I just got a letter saying, okay, we're not going to take action. You can go ahead. What is that letter called? I don't even know what that's called, but the no action letter.
Yeah, I think so. I'm
Um,
not sure what they call it, but I know what letter you're talking about. Yeah.
so that's helpful, I think, to point that out. It's not like it's going to be decided by someone in the commission.
Yeah.
Well, and I think in number one, in the inquiry number one, too, I think where things get blended and where you might have lawyers being concerned that it's being read too broadly is I know at the beginning of that answer, it talks about like the specific situation where it is through the fee dispute resolution, but then later on it says a fee dispute, which fee disputes come up, in everyday practice. That's not between a attorney and a client. So maybe if we just were careful and a fee dispute through, like link it to the process that you're limiting the answer in number one to.
Okay, I've got that.
Is there any further discussion as to 1 and or 2?
Thank y'all for hearing me out on that.
Cindy?
Okay, so if I can just summarize where we are. So in number one, I'm going to clarify the fee dispute through the fee dispute program. And then in number two, we are changing the answer to yes, provided. Provided that the non-disparagement does not, and then the list of those three things, or actually four things. We're going to add not a condition of a return of an unearned fee. Did I miss anything?
The only question I had there, Nicole, as to Brian's point earlier, I think 1 and 2 both track with whether there's actually a duty to refund a clearly excessive fee or not in those circumstances. And whether we wanted to keep that, it depends, as the triggering language in each one or not.
Okay, is that what you were saying, Brian, for number two as well? It depends, or just number one?
Yeah, I was saying number two kind of depends, and I
Okay.
know, Bill, to your point, I understand how it's basically that scenario where there's a clearly owed refund is going to be incredibly limited. It's going to be that scenario where someone actually, I don't know, they took in a $10,000 advance payment and they only earned $8,000. There's clearly a $2,000 refund that's owed, and you can't say, "Well, I'm going to give this back to you, but I'm also going to ask you to sign this non-disparagement clause." That's not okay. Or some other personal injury, just whatever it is, where there's a clear, this is what you are supposed to return to the client. You can't tack this on. But that's most likely not what's going to trigger this. I think most lawyers will be looking at the situation where they don't agree that they owe a refund, and it becomes this dispute. But yeah, that's why I was saying I think it still depends.
Still depends.
Okay, so,
And then you're going to clarify in number five, in inquiry number five,
yes,
that short answer is limited to the facts in number
number
three.
three.
Yeah.
Okay, did I miss anything else?
I think so. with those specific changes, is that something that is minor enough that we go into January with proposal, or is it something that we need to meet again on the finalized version?
Well, I guess what I could do, and Brian, you correct me if I'm wrong, I could make these changes, send it to all of you. You reply just to me, not reply all, but you reply just to me, yes or no.
Yeah, that's okay. And I think if anybody wants to, at this point, it sounds like there is agreement amongst the subcommittee of kind of what the opinion should say. And so if Nicole captures that, I don't think we need to have a meeting that everybody says yes for about 2 minutes and then move on.
That's what I was thinking.
Yeah, I think you all can reply only to Nicole, because if we reply all and there becomes this flurry of reply alls, we might be violating Open Meetings Act. So let's not do that. But if you can just send your feedback to her, and if you want to discuss something, let her know, and she can pass that along to Kevin, and you can call another meeting. Otherwise, the subcommittee can just make its recommendation at the next ethics committee meeting in January.
Nicole, will you put in big fat capital letters right at the top, only respond to me?
I will. In bold, red, underlined, much bigger font. I do it at the beginning of the email and at the end of the email.
Okay, good.
Warren, you and I must be right on the same wavelength, because just about everything you've said, I've already thought in my head.
Yeah.
So I was thinking exactly the same thing.
Sometimes I'm like Dory and Finding Elmo. What?
Okay, and then is your recommendation that it be published for comment? Is that what you want to recommend to the full committee? Warren's
Sounds
nodding
that way. Is
yes.
there anybody
Move.
that
Yeah.
proposes that?
Say yes. Yes from me.
Okay. All right, we don't have
Yeah.
any other business, then
Doesn't seem that way. Sounds like the proposal would be to publish. Everybody will get that email. Just respond to Nicole. Anything else to go over today before we conclude? All right.
Thank you.
Thank
So we
you.
will
It's good to
conclude
see
Don't
this
y'all
meeting.
worry, I've got another one coming down the pike for you.
Hey.
You're not off the hook that easy.
We'll get the band back together.
Oh, boy.
Talking about it.
Thank y'all very much. I appreciate
Thank
the
Thank you.
Thanks for everybody.
thoughtful way y'all
Thank
have
you.
addressed this concern we keep running into.
Thank you. Appreciate it.
Bye.
Thank you.
Thank
Bye,
you,
y'all.
Bye.
everybody.
Bye.
Bye.